In this lesson, we're going to go over the unprotected category of speech referred to as obscenity. So, if we're looking at a constitutional law fact pattern from a big picture, and we see the government is coming along and trying to regulate speech, the content of speech, because the content of the speech deals with sexually explicit material. So usually you'd see regulations that are in some way restricting the distribution or production of sexually explicit material. If we see the government trying to do this on a constitutional law fact pattern, this is our big issue spotter that we have obscenity at issue. We're really going to have to determine in those cases, in those fact patterns, whether the speech being regulated by the government constitutes obscenity. Because we know if the speech being regulated by the government constitutes an unprotected category of speech like obscenity, then okay, that's outside the scope of the free speech clause of the First Amendment, which means the government's going to be able to come in and regulate in those areas without violating the free speech clause of the First Amendment because we're outside the scope of the free speech clause of the First Amendment. That's what unprotected categories of speech are. But on the other hand, if we see the government's coming along and they're regulating the production or distribution of sexually explicit material, but the regulation does not constitute, right? That speech that they're regulating does not constitute an unprotected category of speech like obscenity, then we're going to have a content-based speech regulation that is not an unprotected category of speech. Or in other words, the content being regulated by the government is a protected speech category. And in those cases, we have to apply strict scrutiny. We have a content-based regulation of speech, and it's the content that's being regulated is not unprotected. It's protected by the First Amendment. So that means we have to apply strict scrutiny to determine whether that regulation passes constitutional muster, and we know in most cases, if we're applying strict scrutiny to a content-based speech regulation, the government's not going to be able to provide enough justification to get over that burden. And in most cases, that regulation is going to be struck down in violation of the free speech clause of the First Amendment. Okay, so big picture, that's what we're trying to get at here. And our issue spotter from a big picture perspective in constitutional law fact patterns for obscenity is going to be when we see the government coming along and they're trying to regulate the expression of sexually explicit material. Okay, that's really when we want to think, okay, well, does this speech being regulated constitute obscenity, the unprotected category of speech we call obscenity? Because if it does, okay, generally the government can do that. They're not going to be violating the free speech clause of the First Amendment when they're regulating an unprotected category of speech, because unprotected categories of speech are outside the scope of the free speech clause of the First Amendment. Okay, so that's why we're trying to figure out, does this speech being regulated by the government constitute obscenity? So what is obscenity? Okay, well, obscenity ends up being one of these terms that is extremely difficult to define. The Supreme Court has struggled for decades and decades trying to come up with a definition for obscenity. This is where we get this really famous quote from Supreme Court Justice Potter Stewart. In Jacob Ellis v. Ohio, Justice Stewart writes that, he may not know exactly how to define what obscenity is, but he says, I know it when I see it, right? The Supreme Court says things like, how do you define the undefinable, right, in regard to obscenity? This concept of this really famous quote, I know it when I see it. It's really hard to define, but I know it when I see it. All of this is to say obscenity is one of these things that's really difficult to actually have a really concrete definition of. Okay, so what we get today, though, the most kind of used formulation, if you saw obscenity being tested on a constitutional law fact pattern, you would want to apply the Miller v. California framework. Pursuant to Miller v. California, speech is deemed obscene if these three elements are met. Number one, The average person applying contemporary community standards would find that the work taken as a whole appeals to the prurient interests. Number 2, the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And number 3, a reasonable person applying national standards would find that the work taken as a whole lacks serious literary, artistic, political, or scientific value. Okay, these are the 3 elements we're going to apply if we're trying to determine whether speech is obscene. Okay, and before we kind of start jumping into this and breaking it down, because there's many layers to these 3 elements, I've found that kind of the best place to start, and this is often true anytime we're dealing with something that's hard to define, sometimes it's easier to start with what it is not rather than what it is. So when we're thinking about obscenity and we're thinking about these 3 elements, the first thing I would kind of get out there just to have a frame of reference in our minds are, what are examples of things that are not obscenity? Because we know, okay, obscenity deals with sex, right? We've established that at this point. And if we look at these elements, we see it has to appeal to the prurient interest. Prurient interest just means like an excessive interest in sexual matters. We see that the speech, the work, has to depict or describe sexual conduct in a patently offensive way. So we know the theme here with obscenity is basically sex, right? The depiction of sexuality, right? So let's think about things that would obviously then not be obscenity pursuant to Miller v. California. Okay, what if we have a depiction of violence that is extremely graphic? Like imagine the most possible, grotesquely violent, depiction you could ever imagine, right? Just like the most violent depiction ever put on film. If it doesn't involve anything sexually related, we just have something that is extremely to the nth degree violent, a depiction of violence that's just brutal, right? Is that obscenity pursuant to Miller v. California? And the answer is no. Okay, many times, states and the government have tried to basically challenge obscenity and tried to really expand the definition beyond, mere sexual depictions into actual violent depictions as well. And the Supreme Court has remained steadfast that obscenity is about sex. It's really not about violence. So you could have the most violent thing in the world, like ever depicted, and if it has nothing to do with sex, then it's not going to be considered obscenity pursuant to Miller v. California. This is really important. This is one of those things you see get tested all the time. And students have a tendency to want to say, gosh, this is so violent. This has got to be obscenity. And that's not the test. Remember, obscenity, pursuant to Miller v. California, it has to involve, the expression of sex. It has to appeal to the prurient interests and depict or describe sexual conduct in a patently offensive way. So if we don't have sex involved, then it's not obscenity. Okay, this is one of the first things to recognize. Of course, maybe worth noting, if something is extremely violent, the government might be able to regulate it under some other, formulation, some other category of unprotected speech. We've already talked about how violence is kind of entangled in our inciting imminent lawless action, fighting words, true threats. Like the first 3 unprotected categories of speech, we saw violence was like inherently intertwined in those analyses. So we know if violence is involved, the government may be able to regulate it in other ways, but not under obscenity pursuant to Miller v. California. Okay, so if you saw something really violent it's just not obscenity, but it could possibly constitute some other unprotected category of speech, and the government may be able to regulate it under those analyses, but not under the Miller framework when we're thinking about obscenity. Okay, so number one, what is not obscenity? If it does not involve, sexually explicit material, then it is not obscenity. That's kind of the first thing I would have in our minds as we think about these elements. Okay, so what about things that do depict sexual conduct, right? What are sexually explicit, depictions that we encounter kind of traditionally? Well, the first thing that probably comes to mind is things like movies, TV shows, books, maybe video games, these like forms of media that are mass consumed. Books, TV shows, and movies though especially, right? TV shows and movies often depict sexual conduct, right? And maybe in certain ways appeal to a form of sexual interest. Okay, so our mainstream movies, books, TV shows, and I'm using the word mainstream, things that are consumed by, large amounts of the population, that are produced by, reputable production companies that are, commercially successful, and relatively speaking, are these types of kind of mainstream depictions of sex obscenity? And you probably know the obvious answer is, well, if I'm like consuming it every day and, it hasn't been banned, then it's probably not obscenity. And this is true, right? Most of the time we're thinking about these three elements, and we're thinking about especially this line here in these elements, that we have to take the work as a whole, right? So if you think about a movie, and a movie maybe is 2 hours long or so, and somewhere in that movie there's a really sexually explicit scene that's maybe like 1 minute or something. Okay, well, you have to remember that we're taking the work as a whole when we're applying these elements. We're not pulling out one part of it. We're looking at the whole thing. And that's why typically, one of the main reasons why typically when we look at like mainstream R-rated movies or TV shows that have some sexually explicit features to them, well, when we look at the work as a whole, these elements really are not going to be satisfied, especially when we're thinking about like speech value. There's going to be a lot of serious artistic value and maybe literary value when we're dealing with these types of works, books, TV shows, movies. So for all of these reasons, because we have to look at the work as a whole, and because mainstream movies are going to have a lot of speech value, literary and artistic value. If you're watching documentaries, it could be scientific, political value, okay? So for those reasons, traditional mainstream movies, TV shows, even if they have a pretty graphic, sexually explicit scene or something like that in them, typically not obscenity. Okay, so that's two things. Number one, if it doesn't involve sex in any way, it's only violent, not obscenity. Traditional, mainstream, R-rated movies, TV shows, books, typically not obscenity. Okay, so if we keep moving along the spectrum though, okay, if we're thinking if we think of obscenity as kind of this like spectrum, and maybe over here on this side of the spectrum, we have like mainstream TV shows that have some depictions of sex in them. Okay, well, we know that's not obscene. How can we get closer to the line where something becomes obscenity? Well, think about like mainstream, traditional pornography. And again, I'm using mainstream and traditional kind of in the same way. Produced pornography that's produced by, reputable distributors that are really just kind of depictions of nudity and sex, where even if you look at the work taken as a whole, it's not just like a small part of it involves sex. Like the whole work is basically depicting sex, right? This would be magazines where every page there's a lot of nudity, or pornographic movies where, pretty much every scene is going to be sexually related. It's going to show depictions of sex. Is this, though, when we're thinking about kind of mainstream traditional pornography? And I mean this again in the sense that you have like a reputable production company, all of the actors are the appropriate age, are not minors, everybody's consenting, there's like no bad faith or crimes being committed, it's all above board and reputable, like mainstream, traditional. In those cases, it's pretty well established law that that type of pornography, which you would think of as kind of like the reputable mainstream pornography, is not obscenity, okay? So even as we move along our spectrum, like R-rated movies with graphic depictions of sex, probably not obscenity. Even getting to like pornographic movies that involve, more and more graphic depictions of sex, probably not obscenity if the production value, so to speak, is there, where it's the process and the production of it is all in good faith, above board, everyone's consenting, everyone's an adult, everything that you would expect with like a reputable production company producing it, okay? Probably not obscene. So these are the things where I would kind of say that's where at least we have well-established law. If it's like really difficult to define obscenity and we're trying to say, okay, well, what does the case law tell us is not obscenity? Well, if there's no sex at all, it's not obscenity. That's at the lowest end of our spectrum. And that could be like, it could be really violent, but not sexual in any way. Okay, it's not obscenity pursuant to Miller. Then we get to like rated R movies that are still mainstream. Not obscenity, even if they have depictions of sex. Okay, then we get to like magazines that have depictions of a lot of nudity. Again, probably not obscenity based on the case law. Mainstream, traditional pornography, movies, still probably in most cases not obscenity based on the case law. And below the video, we can put all of these cases if you want to go and read all the different cases on this. And we'll talk about some of it with Ginsburg, Stanley, we're talking about Miller. So we'll talk about some of these different cases, but we'll put a comprehensive list below if you want to kind of get into all the case law. But that is, pretty well established. So, past that point though, when we get past like mainstream, what we're calling mainstream, traditional pornography, that's when we can start to cross into lines of obscenity. Basically, in most cases where you see material actually deemed unconstitutionally, basically obscene, where it gets into this unprotected category of speech, is when you have pornography, but it's not like the traditional mainstream. There's like elements added. Almost you could think of like in criminal law where we have aggravating factors, where there's things that are done, usually in the production, that just kind of tip the scale a little bit and it becomes obscene. Maybe when you mix in things that are really violent. We said violence alone is not enough to be obscene. We have to have this appeal to the prurient interest, and we have to have a patently offensive depiction of sexual conduct. So if it's only violent, it's not obscene. But when we start mixing sex and violence, that can be a recipe to get to obscenity, right? If you're depicting torture and violence and mutilation in a sexually explicit way, okay, that's when we start to get past traditional pornography and we start to get into some aggravating factors almost that could get you into, okay, maybe this does constitute obscenity. But it's important to recognize that that line is not bright. It's not a bright line rule. And often we're going to see it's kind of subjective. So, rather than trying to sit here and be like, okay, what's on this side? What's on this side? Now we can kind of say, well, we know from established case law what is definitely not obscenity. Rather than trying to now find, okay, but where is the exact line? We can kind of get into the Miller framework, because this is what the Supreme Court in Miller was trying to do. You know, in Miller, what the Supreme Court's goal when they came up with these three elements, it was like, let's give jurors, you know, the people at trial that have to find the facts, they have to determine what the facts of the case are. Let's give the jurors an analytical framework that they can use to try to figure out what obscenity is. Let's give them some clues. Let's give them a path, a framework to figure this out. Okay, and I think it's important to see it in this lens. This is what the Supreme Court in Miller was trying to do, because that's going to help us kind of, in a second, we're going to talk about the difference between community standards and national standards. And this is kind of where, you know, it's important to recognize what the goal was here. And in Miller, the goal was to give jurors, you know, the jury, a analytical framework to use in kind of defining what is obscenity. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.